This is case number 25-5150 FY. Appearances, counsel.
Nate Carnes on behalf of the people.
I'm Jeff Harrison. I'm here on behalf of Mr. Peterson. He's joined me at the table.
All right, counsel, we were originally here for a preliminary examination. I've been handed a waiver of that. But before I sign the waiver, Mr. Peterson needs to be arraigned on an amended complaint. Mr. Harrison, were you aware of that?
We were aware of that. We've made a couple of efforts to arraign him on this complaint. For various reasons, we just haven't been able to get all the paperwork in the right place at the right time. So yes, we're aware of it.
All right. Mr. Peterson, I have an amended complaint that alleges that on or about December 20th, 2025 in the city of Manton in Wexford County, count number 1 has been amended to controlled substances possession of a narcotic 50 grams or more, but less than 450 grams. That is a felony punishable by up to 20 years in prison and or a fine of $250,000. Count number 2 remain the same of operating while intoxicated as a third offender. That means that's a felony punishable by a fine of $500 to $5,000 and either 1 year to 5 years or probation with 30 days to 1 year in jail, at least 48 hours to be served consecutively, and 60 to 180 days of community service, rehabilitative programs, reimbursements for the cost of prosecution, governmental expenses, mandatory vehicle immobilization. And in count number 3, it's alleged that you committed the offense of operating while your license was suspended, denied, or revoked as a second or subsequent offender. That is a misdemeanor punishable by up to 1 year in jail and or a fine of $1,000 in vehicle immobilization. Do you understand those charges in the amended complaint?
Yes, sir.
You do have the same rights that you had when you originally arraigned, so we will go ahead and continue the appointment of an attorney, enter the not guilty plea. We will keep bond set where it was previously at. And counsel, before I sign the waiver, is there anything else we need to address on the record?
I don't think so, Your Honor.
Mr. Cummings? All right.
Sorry, Your Honor, if you're speaking, I see you're muted.
Sorry, I apologize. I just asked if there was any resolution to the case.
All right.
Mr. Harrison indicated there was not as of yet. Obviously, he's not able to post a 25% bond. So that brings me to my next question. Mr. Harrison, are you planning on a prelim next week on this?
I don't see that there would be any, frankly, any reason to conduct a prelim. I'd like to keep the date in the air just so there's some incentive for us to resolve whatever we can resolve.
All right.
Do you discussed it with Mr. Mayor? We don't believe there's any logical reason to hold a prelim.
Sure. Do you have the discovery you need right now, do you think?
I do not. But that could be just a matter of it being processed.
All right.
The public defender's office has been in contact with us.
Who should we send the discovery to? I'm sorry, Mr. Harrison. What's your first name?
It's Jeff Harrison. I'm the public defender on the file. I didn't know that another appearance was even contemplated.
All right.
I'm not sure there was. I think there's just some confusion as to who had what case. So
I share in your confusion.
So Ms. Getz is not on this case. All right.
Okay.
We will get, Mr. Harrison, we will get you the discovery packet. I'll have it emailed to you this afternoon. I assume all your contact information is in the bar journal.
Correct.
All right. And
then
we'll plan not to bring any witnesses then to the prelim, which I
think that's correct at this juncture. We'll discuss it in between.
Okay. And you know the standard offer in these cases, correct? All right.
Yeah.
all right, then we will keep the matter set for prelim next week and we'll see where we wind up. Anything else for the record, counsel?
Sounds good, Your Honor. Thank you very much.
All right, thank you. Okay. Counsel, we are here for a probable cause conference. Is there any resolution in this matter?
There is none, Your Honor.
So that means, and we don't have a waiver of the 21 days, is that correct? So that means we are set for a prelim next week. Mr. Harrison, do you have everything that you believe you need for that?
I believe so.
Ms. Dahl, are you aware of any issues that might pop up between now and then?
Yeah, okay, for prelim. Okay.
I don't have any information. Any delay.
All right. Then we will keep this on track for a prelim for next week. Anything else for the record, council?
Nothing at this time.
No, Your Honor.
All right, thank you. Ms. Webster, just a reminder that your bond conditions continue. All right. You can go out to the front window where you checked in and get your next court date. Thank you. This is case number 26-147 FD, appearances counsel.
Isabel for the people.
And I'm Jeff Harrison. I'm here on behalf of Ms. Squire. She's joining me at the table.
And we are here for a probable cause conference. Is there any resolution?
There is no resolution, Your Honor. We did indicate that we waived the 21 days in this case because there was a blood draw.
Okay.
And I just don't want to get here next Tuesday and have there still be no blood draw and have to adjourn. So.
All right. And counsel, you haven't received the blood draw on this one yet?
No, I'm not, Your Honor.
All right. Okay, yeah, and this just happened last week, so. all
And
right.
we're working diligently to resolve it as well.
Mr. Harrison, then I'll defer to you. Are you asking to have this set to the 27th, or do you want to go another week out?
I think to be safe, we should go another week out.
Any objection to that, Ms. Dahl?
No, Your Honor.
That'd be February what?
It'll be
third?
February
Third.
3rd.
Third, okay.
All right. Then we will set this out to February 3rd. Anything else for the record?
No, Your Honor.
Nothing from us, Your Honor. Thank you.
All right, Ms. Squire, just a reminder, your bond conditions continue, and you can go out to the front window where you checked in and get your next court date.
Thank you.
All right, thank you. All right, this
On behalf of the people.
is case number 26-129FY. Mr. Bradachowski, or I'm sorry, Bartachowski, you had indicated at your arraignment you were going to hire an attorney, but we don't have an appearance yet. All right, I'm sorry, I can't hear you. All right. The court will then make a referral to the public defender's office for the appointment of an attorney. We'll continue the not guilty plea and we'll reset this matter for a probable cause conference. Any objection to that, Mr. Carnes?
No, Your Honor.
All right. Sir, you can go out to the front window where you checked in, get your next court date. You'll have some paperwork to fill out for the defender's office. And just a reminder that your bond conditions continue. Okay, thank you. This is case number 26130FY, appearances counsel, starting with the prosecutor.
Nick Carnes on behalf of the people.
Good morning, Your Honor. Allison Castles and Attorney Lynn Getz on behalf of Mr. Finney.
And we are here for a probable cause conference. Is there any resolution in this case?
There's not, Your Honor. We've still not received body cam discovery. I spoke to Mr. Carnes, who advised he's also not received that. So we'd be asking to set the preliminary exam out about 3 weeks.
Mr. Carnes, how long do you think it's going to take to get body cam? That's usually a pretty quick turnaround, isn't
It
it?
usually is, Your Honor, but we're dealing with the fugitive team. We did send out an email on Friday and that got forwarded on to somebody else at MSP that we've never dealt with before. I would hope we'd have it in the next day or two. I do think a 3-week adjournment is appropriate given the nature of the case, defendant's out on bond, and there could be a fair amount of body camera for us to review before we can resolve it.
All right, given the stipulation, then we will set this matter for preliminary examination and we'll go out February 10th. Is there anything else other than body cam we're waiting for?
No, Your Honor.
Anything else for the record?
No, Your Honor.
No, Your Honor.
Mr. Finney, just a reminder that your bond conditions continue and you can go out to the front window where you checked in and get your next court date.
All right.
All right, thank you. Case number 26-116FY, appearances counsel.
Isabel for the people.
Robert Hartel from Mr. Oxford. I am filling in for Ms. Fiobento, Your Honor.
And where's Ms. Fiorvento?
She's in Misaki County on other cases, Your Honor.
She's in trial over there today?
No, I should have phrased that better, but there's arraignments over there. She was on the Misaki arraignments.
Mr. Oxford, you do have the right to have your appointed counsel present. Are you okay with the substitution today? Is there any resolution in this matter?
There is not, Your Honor, but we would waive the 21 days.
So that will put us out to the 3rd. I'm sorry, Ms. Dahl, this is your case?
Yes, it is, Your Honor. I'm fine with that.
All right. Are there any discovery issues we need to be concerned about?
I believe there needs to be some clarification on how the drugs that were delivered were identified. I know there was a narc, so I'm waiting to hear back from the officer in charge on the identification of the substance.
All right, so I'll just make note of that, and if something happens that we need to adjust the prelim date, we can do that by stipulation.
Thank you, Your Honor.
Anything else for the record?
No, Your Honor, thank you.
Case number 25-2894 FT. Appearance of counsel.
Please sit all for the people.
Robert Hartzell from Mr. Callahan and joins with the table.
We are set for probable cause conference. Is there any resolution to this matter?
There is not, we would waive the 21 days on this one as well, Your Honor.
All right. Ms. Dahl, are you aware of any discovery issues?
Yes, Your Honor, I believe this case was already continued 1 week because we are waiting to hear back from an officer regarding another witness that I would need for the preliminary exam. I have not heard back from the officer. I know the officer replied that he's working on it. So I've not heard back yet.
All right. And it looks like we were originally scheduled for the 13th. We did that adjournment back on the 12th. So if we go out to the 3rd, do you think that that would be sufficient time?
Your Honor, I hope so. I did also get some information of the victim in custody. So I need to writ that as well to testify.
Is it DOC custody or?
I
County.
believe it's in the Waco jail, but I'm not sure.
Okay. All right. Mr. Hartel, any objection going out to the 3rd?
No, Your Honor, no objection.
All right. We will set this for a prelim on the 3rd. Mr. Callahan, just a reminder that your bond conditions continue and you can get your next court date at the front window. All right. Thank you.
Talk soon.
This is case number 26-99-FY, appearances counsel.
Nate Carnes on behalf of the people.
Robert Hartzell for Miss Emard, who joins with the table. This is another one where I am filling in for Miss Viavento, who's on arraignments in Missouri County.
All right. Ms. Emard, you're aware that Ms. Viavento is your appointed attorney in this matter and she's not available for today's date.
Yes, sir.
Are you all right with Mr. Hartel filling in for her?
Yes, sir.
All right. Counsel, we're here for a probable cause conference. Is there any resolution of this matter?
Yes, Your Honor, it's my understanding that the defendant will enter a guilty plea to an added count of child abuse fourth, and there is a Killebrew agreement for sentencing under HIDA in this matter.
Guilty plea, you said?
Yes, Your Honor, it is with the HIDA elements.
Mr. Hartel, is that your understanding of the plea agreement?
It is, Your Honor.
Ms. Emard, will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
So it's my understanding that you'll be pleading guilty to an added count 2 of child abuse 4th degree. That is a misdemeanor punishable by up to 1 year in jail or probation for up to 5 years. Additionally, I believe there's a $1,000 fine that goes along with that.
Okay.
In exchange for that, the people will be dismissing count number 1 of 3rd degree child abuse. That is a felony punishable by up to 2 years in prison or probation for up to 5 years. Additionally, there is what is called a Killebrew agreement. That's an agreement you have with the prosecutor that says you would be sentenced under what's known as the Holmes Youthful Trainee Act. And if you're successful with that period of probation, the charge would be removed from your public record. If you're not successful with it, however, though, the charge would enter. Do you understand that?
Yes, I do.
Now, do you also understand that that's an agreement you have with the prosecutor, not an agreement you have with me? So if I decide that I'm not going to follow that agreement, you would be able to withdraw your plea. Do you understand that?
Yes, sir.
Back on May 19th of last year, were you on probation or parole?
No, sir.
Were you on bond?
No, sir.
Do you understand that you have the right to have a jury trial, have witnesses called for your defense at trial, to cross-examine those witnesses called against you, the right to testify or remain silent, the right not to have that silence used against you, to be presumed innocent unless proven guilty beyond a reasonable doubt? Do you understand though?
Yes, sir.
Most importantly, do you understand that by entering a guilty plea today, you'll be giving up that right to have a jury trial and you won't have a trial of any kind?
Yes, sir.
Other than the plea agreement, has anybody promised you anything in order to get you to plea?
No, sir.
Has anybody threatened you in any way?
No, sir.
And is it your own free choice to plead today?
Yes.
Are counsel aware of any other promises, threats, inducements not made part of the record?
No, Your Honor. No, Your Honor.
Then Ms. Emar, to the allegation that on or about May 19th, 2025, in the city of Cadillac in Wexford County, how do you plead to child abuse 4th degree?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So what happened back on May 19th?
My friend had her dog over and we were uncertain how he was with kids, and I looked away for a few seconds and he got my daughter and I neglected to take her in.
Neglected
In
to
my
what?
mind,
I'm
I
sorry.
didn't think it was bad enough to take her in.
All right. Did she sustain injury?
Yes, she did.
And what types of injuries did she have?
It was just a small scratch to the face on her left cheek. Or no, yeah, it was the left cheek, and then her cat got her 10 minutes later in the same spot.
So the cat scratched her?
It just got a little pin poke right at the top of the dog bite.
How did it get the pin poke?
I'm not exactly sure. She was downstairs with my mother.
Okay. And do you know what happened with the dog? I mean, how she was injured by the dog?
I looked away for a couple seconds and he must have like jumped up and like got her right on the cheek. I didn't exactly watch it happen. I just,
How old is your daughter?
she was 2 at the time. She's 3 now.
And how familiar were you with the animals?
I knew the puppy since the owner got it. He never showed us like signs of aggression until that day.
How familiar were you with the dog?
Very familiar with the dog.
How old would you say the dog was?
8 months,
Had your child been around the dog before?
like 2 or 3 times prior.
And had there been any issues before?
No,
And was there I think you said, but I can't remember, was there somebody with your daughter when the dog either bit her or did what it did?
it was me and my friend Michael, but she was not paying attention either.
And how far away were you from your daughter when it happened?
Maybe from me to the corner of that table.
Counsel, I can't accept the plea. Zmart, it's nothing you've done wrong. It's just based on that factual basis. I don't find that that you knowingly caused the situation or acted in a way that would have unreasonably caused the situation to happen. So, counsel, do we want to keep this on track for preliminary examination? Do we want to reset it for PCC?
Your Honor, if possible, if we can reset it for PCC next week and a prelim the following week, that way I'll be gone next week, so. That February 3rd.
Any objection to that, Mr. Hartel?
No, Ms. Fiovenzo also informed me she'd waive the 21 days, and my client confirmed that would be acceptable as well, just so the people in the court both know that.
Correct me if I'm wrong, but Ms. Fiovento's in a 5-day trial that following week, the 27th.
I'd have to double check that.
All right, we will go ahead and we will reset it for probable cause conference next week.